Good morning, good evening, good afternoon, Earthlings. Today we shall talk about Harry settling with, was it the Mirror Group? I'm pretty sure it was MGN. Last year he brought 33 stories that they'd written, and the judge found on the balance of probabilities that he had a case on 15 of them. Harry's team and of course all his little fans saw that as a win. Me, not so much, because court cases aren't like that. They're very rarely a clear, pure win, in my experience. And also, when I used to study law, which was a very long time ago, especially with criminal law, what they say in the books and what actually happen in court are two quite different things. And I was really interested in the comparison between the two. And I suppose it may vary from region to region, or judge to judge, or clerk to clerk. The clerk, in my experience, is really the one who rules the roost of the court. They can be quite bossy, actually, and usually highly experienced. Today we're going to talk about Part 36 settlements and, well, offers, and Part 36 payments into court. Now, Harry's side, of course, are going to crow this as a win. But from my point of view, just as a pleb, just as a viewer or a spectator, I don't see it as a win at all. Because, well, it is and it isn't. In a way, it is because it's gotten him out of one of these court cases, and he has a lot. And I know how ageing and stressful and tiring they are, and they literally suck the life out of you. They suck every waking moment. In fact, when I was in litigation, I struggled to go to sleep at night, and every morning I woke up, I was worried. But that was the case from the day we bought our boat as well. The very day we bought this boat in Gibraltar, when we were back in the UK, I went to sleep every night wondering what was going on with it, and I woke up every morning wondering what was going on with it. We bought it in 2007 and we didn't move down here until 2010. So that was 3 years of sleepless nights. And then the litigation came later, which was another enormous thing in our lives. So last year, David Sherborne delivered a really empiric speech about slaying dragons, didn't he? Harry has slain dragons. And I don't know if that was a reference to the Prince and Princess of Wales and the Welsh dragon, or if it's just a coincidence, that's up for speculation. But oh, how far to fall to suddenly settle out of court on a Part 36 offer, or Part 36 payment in. I think they might have paid some in. Now, why he did that, I don't know. Could have been stress, could have been money, or there can be other reasons. And so I dug out my civil procedures, my old faithful. Now this is an old copy. It is, to give credit to the authors, Civil Procedures by Paula Loughlin and Stephen Gurlis. Stephen, I believe, is a judge, district recorder. And this is a second edition, which is 2004. So this is quite an old book. And as I always explain, I am not a lawyer. I'm not here to give legal advice. Certainly never take my advice. In fact, my advice would be, don't take financial, medical or legal advice from the internet generally. It's only for research. And this is just topical. And I found this particular case law, which I thought might interest some of you, because I've tried to explain before, with suing people and civil actions. A massive word in the civil system is reasonable. Another massive word is unreasonable. Those words crop up all the time throughout this book and other books of speciality of defamation or other torts. Being reasonable and being unreasonable are massive considerations for civil courts. So bear that in mind, ladies and gentlemen, if ever you're thinking of suing somebody. My personal advice, for what it's worth, and it's not legal advice, is if you can avoid litigation at any cost, avoid it. I actually had another court case, interestingly enough, in Gibraltar. I was the first person to make an appeal against a data protection order, and I won, and I represented myself. It was in the magistrates, and my opposing lawyer, who was representing the relevant authority, a wonderful guy, and we really hit it off afterwards. You know, he was quite miffed to lose to what they call, what do they call us? Litigants in person, I think. But I wasn't a litigant exactly, because I was appealing against an act of parliament. So it wasn't a lawsuit. I was appealing to the magistrates against a decision of a data protection nature. So he was quite miffed to lose to a lay person. But afterwards he came up to me and he said, you know, well done. You actually had right on your side on that one. And he has now gone on to specialise in mediation. Because, and I spoke to him about this, and I said, you know, when I was in litigation, all I want is my defendants to sit down and listen and talk. And they just won't. And I know why they won't, because there were 3 of them, and one of them had lied through his arse not to find a point on it. And he knew if he agreed to sit down in mediation, all his lies would fall apart very quickly, and the other 2 defendants, who were way superior to him in this system, would be very angry with him to find out that he had told some whoppers to them, and that they had backed him to the hilt, so that I had to drag them to mitigation, kicking and screaming all the way. Anyway, that's beside the point. This lawyer that I was up against in magistrates, he said that in all his years' experience with litigation, he had seen people's lives torn to shreds, families destroyed, lives destroyed, businesses destroyed, and that's why he went to focus on mediation and arbitration, which civil courts really, really like. They like it if parties have tried to resolve their differences rather than relying on the court and arguing the toss to the bitter end and every I and cross every T. Courts hate that. It's called wasting their time, otherwise known as being unreasonable. And I said to him, how do you enjoy that work? And he said, honestly, Fiona, by the time people come to me for mediation, they've torn themselves to pieces. Them and the other side are so wounded, they are so injured, they're covered in metaphorical blood, and really, by that stage, they are just so exhausted, they'll basically agree to anything to get out of it. So bear that in mind with Harry. And not only that, Harry's quite unusual. I mean, he should be in the Guinness Book of Records, really, for how many court cases he's got on the go. All of his own making, I hasten to add. You're not going to hear sympathy here. It's one thing, because when some of these actions were begun, he was in the royal family, a privileged prince, you know, with money is no object. It's a point of principle, which is easy to say when money is no object, isn't it? And you have servants, which the rest of us call staff and colleagues, but servants who will deal with this, you know. I went to private school. This is just an aside. I've just remembered this. And I always felt, or when I was at private school, there were some really, there were lovely girls there. But I always sort of got the impression that because my dad was a solicitor, I was kind of considered one of the staff, you know, daughter of one of the staff, because some people are that alto. So that's probably how Harry saw it. But then once having left the family, at that stage he didn't realise he was going to lose his security. Having left the family, then realising he's got to pay for his own security, he's got to pay for a court case to fight for the right for security, he's gotten himself involved in other lawsuits. The guy's gone bald. I mean, you can see physically the wear and tear on him, and I do believe I mean, he's not even 40, I've said it before. Right, so I thought I'd read this case out to you. Now, case precedent, there's bound to have been other cases that have come along, so I don't know if this case is even relevant or not these days, but I thought I'd read it out to you because it's very short. In Amber versus Stacy 2001, the claimant brought a claim for an unpaid invoice. After proceedings were commenced, by letter dated the 1st of October 1997, the defendant made an offer to settle the claimant's claim for £4,000. This offer was not accepted, and on the 7th of August 1998, the defendant made a payment into court in the sum of £2,000, and on the 20th of January 1999, a further payment into court of the sum of £1,000. At trial, the claimant failed to recover more than the amount of the payment in. The trial judge ordered the claimant to pay the defendant's costs incurred from the 1st of October 1997 until January the 20th, 1999. Ouch! Ouch! And that's because the claimant was being unreasonable. That was a fair offer. Now, maybe Harry saw the offer, Part 36 offer, and Part 36, if there was a Part 36 payment into court, and said, "Oh, be off with his head, I slay a dragon." And perhaps Sherborne said, "Actually, it's not that simple, Harry," and had to explain the consequences. Now, an offer, apparently, according to this book, which is wildly out of date, doesn't have to be made in any particular format, but usually it's a letter, and there are certain things it's got to have, like what case it's about, case number, how much, whether they're offering to pay all or some. Because, this is another thing I thought I'd mention, if anybody's considering suing anybody, when you sue somebody, that person becomes the defendant. And that defendant can come back at you with a counterclaim. So that's effectively, you're getting sued back. So then you have to put in a counter defence, and so on and so on. Now, this whole section, if you ever get the chance, in fact, the current civil procedures are actually on the government website. Just look up civil procedures, and then you can go through all the sections. It's really a common sense thing. It's wonderful. And I will just read you out another bit, which is why this sort of came apart. This is from Lord Wolfe, who said, "My approach to civil justice is that disputes should, wherever possible, be resolved without litigation. Where litigation is unavoidable, it should be conducted with a view to encouraging settlement at the earliest appropriate stage." I couldn't have said it better myself, Lord Wolfe. If he's still alive, I've no idea. So it's a book of common sense, and you can go and look this up on the... In fact, I'll put a link. Silly me. I'll put a link in the description, and then you can go and look at it. And you can look up certain parts, and you will find the word unreasonable and the other word reasonable throughout it, like a thread of gold. And from what I've seen of Harry's hothead and unreasonable behaviour, he's just the worst person in the world that should be getting into any kind of litigation. He should be locked in the toilet with gaffer tape over his mouth for his own safety, and should not be allowed to launch any further lawsuits. It should have to go through a committee or something. It should make the law of Prince Harry for his own safety. I mean, really, you've no idea. I mean, there are smaller claims and there are lesser things, but the things that Harry's suing for, these are biggies. And everybody in the world is watching. And he settled. Personally, I don't think he could afford to go much longer. And when they say that they've paid in some figure like 400,000, oh, David Sherborne and his team of merry men and women, 400,000? I'll wager they cost a lot more than that after all this big doodah with the Mirror. And of course, shareholders, Reach PLC, they own the Mirror, I believe, and every time there's a settlement or a loss on Harry's part, the shares just skyrocket. And I mean, that's the gold standard. Look at the share value of Reach PLC. Because shareholders don't like litigation, and I don't blame them, because it can go either way. And on a matter of frivolity, because I vaguely remember this case. You know, when people enter a contract, it says you have to be over 18. And I recall reading the case law that created that, and it was, I think it was Victorian days. Lawyers out there be cringing thinking she's getting all this wrong, but this is from recollection. There was some teenager, I think he went to Eton, and he went down somewhere like Savile Row. He was about 17 years old, 16, 17. And he said, oh, I want a set of waistcoats, multicoloured, pure silk, woven by virgins, you know, really expensive stuff. Had this whole load of fabulous silk, colourful waistcoats made. And when it came time to pay the bill, he said, oh, whoopsies, I haven't got any money. And they took him to court, and he said, oh, but I'm just a child. And the court said, well, a child isn't really capable of entering into a contract. And there, I believe that was the embryons of the... It's very interesting, the law, how things form and develop. And the cornerstones really are reasonable and unreasonable. So, if ever you're thinking, am I breaking the law? Generally speaking, is my behaviour reasonable or unreasonable? You know, I don't like that guy, I'm going to punch him in the nose. That might not be reasonable. That might not be a best first course of action. Because I've found that when you behave like that, then generally you can stay pretty much within the confines of the law without... Obviously, there's always these little itty-bitty laws, you know, you must hop on your left leg on a Thursday afternoon, unless it's the third Thursday in the month or whatever. There's always going to be that nitty-gritty kind of law that we all fall foul of. But the general, you know, to avoid common law, they're the biggies, you know, murder, theft, etc., etc. This is criminal law, of course, and with civil law, definitely, or if you fear someone's going to sue you, a reasonable thing is to reach out to them and try and talk to them, reason with them and negotiate or mitigate and keep a record of it so that you can then show the court that you have reacted and behaved in a reasonable manner in the eyes of the court. So from the beginning of the dispute, bear in mind a judge may be watching, listening, or reading letters, emails that you've sent. And would you say that kind of shit in front of a judge? Anyway, so there you go. Those are my thoughts and opinions on that. I might be going live on Wednesday, but I'm not sure yet. And if so, I'm not sure what time, because I might have a guest. But you know how these things can be when you've got to try and organise somebody else and what times they're going to be available. So keep your eyes peeled for that one. I am working on my other video in the background, which will be forthcoming in a few days' time. As always, I hope you're having a wonderful day and look forward to reading your thoughts, opinions, and your conjecture as to why you think Harry settled out of court on this occasion when there was a dragon to slay.